Thanks so much, everyone, for staying with us. So, Nigeria's electoral umpire is once again at the center of a very big controversy. The Independent National Electoral Commission's position on the leadership crisis within the African Democratic Congress has now sparked fresh legal and political debate, raising questions about party autonomy, regulatory boundaries, and the implications for the 2027 general elections. At the heart of the dispute, INEC's reported withdrawal of recognition for key figures within the ADC leadership structure, including former Senate President David Mark and ex-Governor Rauf Aregbesola, triggering fears over internal legitimacy, compliance with the Electoral Act, and even the party's eligibility to appear on the ballot in 2027. So, where does the law stand? How far can INEC go in determining who leads a political party, and could internal party dispute reshape the electoral landscape ahead of the next general elections? To unpack the legal and institutional implication, I'm now being joined by Mr. Oluwole Osazi Uzi, a former INEC Director of Legal and Equality, a former Director of Voter Education and Publicity, who has decades of experience and as a lawyer and electoral principles will help guide our conversation tonight. Mr. Osazi Uzi, thanks so much indeed for joining us tonight.
Thank you for having me. Good evening.
I appreciate it. Thank you so much. Give us an understanding. INEC procedurally has come out to say this is, and I know that a lot of the times over the years in the way politicians behave, they going from one court to the other, extracting court cases, and you find one court case in order in Zamfara, another one in Gombe, forum shopping legally called, and yes, they will present it for INEC, and you'll be torn between several options in the middle of the controversy. But you've got, as a regulator, INEC had to make a decision. But this decision that INEC made in the case of ADC, yes, and the now INEC chairman referring to what he called the status quo ante bellum. Yes. Legally speaking, I'll need your explanation as a senior lawyer on what that meant. What is status quo ante bellum? And in fact, procedurally, the decision of INEC to remove David Mark and Aregbesola's name as a leadership of the party, where does this leave the party?
In dire straits. In 2 words, dire straits. Because if INEC withdraws its recognition, it means, in effect, that it will not accept any list of candidates from the political parties. The political party will not be invited to any meeting. It will not, in fact, basically dead for this period that is not there. Because INEC only takes, by its own regulations, only takes correspondence, only listens and invites the national chairman and national secretary. And when it comes to submitting lists of candidates, it gives you a code. Without that code, you cannot access the INEC portal to submit the list of your candidates. So if it does not recognize any chairman or secretary of that, national chairman, national secretary of that party, that means that party cannot submit its code. If the party does not, if the national chairman, national party doesn't sign a notice that they want to conduct a congress and a convention, it means INEC will not monitor. And if INEC does not monitor that congress, give notice to the commission, it means it will not, any list of candidates emerging from such exercise will not be recognized.
Sorry, before you go on that note.
Yes.
ADC says we don't care whether you are monitored or not, referring to INEC now.
Yes.
That they will go ahead as planned to conduct their, under the David Mark and Aregbesola's leadership.
Yes.
We go ahead and plan and conduct our convention.
Yes.
As far as the Constitution is concerned, monitoring and observing party activities is a duty. But is the party bound legally? What is the legal implication of monitoring of election? Does it make it legally invalid or valid, as the case may be?
Good question. We have to put things in context. Yeah. Now, if a party does not give INEC notice of its congress or convention, its electoral act, not the Constitution. The Constitution gives power to INEC to monitor the activities of political parties, including their finances. Yeah. Then the electoral act goes further to say, look, if you are going to select candidates or select an executive, we have to be there. Now, that of ADC, as far as I'm aware, is interesting because as at the time that the David Mark executive or working committee was constituted, INEC monitored that. INEC, they've also given INEC notice, and INEC recognized that and put it on the website. So INEC recognizes the David Mark and Erebushala committee up till very recently, recognized that and accepted a notice. They gave them notice of its desire to conduct congresses and conventions. So it has given that notice. Now, if you have given that notice to INEC, at least 21 days notice, whether INEC comes or it does not come, that does not validate or invalidate the process.
So they are good to go with the convention.
As it were,
in the eye of the law, in the eye of the law, whatever happens at that convention, as far as it's immaterial whether INEC is there or not, is after the fact, as far as the law is fait accompli, as long as the monitoring, as far as the notice is concerned, which is the mandatory procedural requirement by law. So whatever happens, whoever emerges at that convention, which is going to be an electric convention, is legally binding.
It's legally binding.
Even if INEC is not present.
As long as they've given INEC the notice of election. There are several congresses and conventions, INEC has not been present for one reason or another. But once it has given notice of that, once the party has given notice of that, then its mere presence or absence does not validate or invalidate.
But the PDP convention in Ibadan, INEC was not there, and it became invalidated by the court.
Yes, that was because you have to look at things contextually and why the courts give the judgment that they give. Because I think, if I recall correctly, it is a question of you went ahead against a valid court order. Specific order for you not
conflicting
to hold,
order.
Not to hold.
There was an Ibadan court which says go ahead.
Correct.
There's an Abuja court which says don't go.
And no party, no person, no litigant should be faced with conflicting court orders of coordinate jurisdiction or equal courts, the courts of equal jurisdiction.
So now, ADC, legally speaking, procedurally, they are in good standing. At least as far as the law is concerned, in terms of the notice of their convention. However, the removal of the name of Erebushala and David Mark by INEC, legally speaking, did INEC do the right thing in that context?
I listened to the INEC chairman explain why the commission did what it did. I also read the 5-page statement. It's a long statement, it's unprecedented, and they took their time.
Looked more like a legal explanation.
It was an explanation. So what the statement was gave the basis for the decision with the read. I may not agree with that decision, and many lawyers, I'm afraid, will not agree with that decision. It's a question of interpretation of what the status quo ante bellum was. And a lot of people asked at the time that the case went to court, what was the status quo ante bellum? And you did ask me your first question, what did you mean by that? It means before the hostility started, before the disputes, as it were, started. And one thing, the law recognizes once you have a political party, it must have a chairman, national chairman, it must have a national secretary. Be it in an acting, a provisional, but there must be one. You cannot have it's like having a human being without a head. It's not possible. So you must have. So what INEC has done basically is I said, this party does not have a chairman.
But let's mathematically look at the law.
Yes.
What is the rest in this case?
Good question.
So because it will help us to now find X. Because we're looking for status quo antebellum. Because what Nafi Bala is saying is that as at the time Uwosu stepped down, I am the I'm the man that should naturally step. So there are a lot of people who say that is the antebellum there. That is the point where that is the conflict.
Did he step into those shoes? Was there any party meeting? Was there anything where he stepped into those shoes? Or is it an automatic thing? People will say antebellum, then maybe go back to Ralph Wonsu's as still being thing. That's what happened before the...
And simply before the status quo antebellum. For those who don't understand the Latin word.
Yes, it means I think most people understand the status quo, how things are. And so antebellum, how things were before the commencement of the hostilities. So how were things? When was the hostility? Was the hostilities 2nd of September when Bala went to court? Was it as at when Wonsu resigned or Wonsu was there? Or was it a question of, don't forget, INEC recognized these people. A classic case was that of Ojukwu against the governor of Lagos State, and you read law, so that's a classic case. Now, at the time, the Supreme Court held that Ojukwu was forcefully removed from the house. They said, no, return him to the house, pending when we take his application. remember, what the Risca Villa, you're sitting in front of the house, say, no, that is wrong. While the case was in court, you don't usurp the powers of the court or render nugatory what the likely outcome is likely to be. So what was it? There's Vaswani and Sawalak, old 1972, more than 50 years ago. And they said, look, a man lost the case and said, look, I have a motion for stay of execution of the state. So don't do anything. Don't remove this man pending when the court can actually hear the case. So that's the same kind of thing. What, before the dispute arose, was Bala at any time chairman of the party? So apparently, INEC says no. So, but was David Mark and Areboshla chairman and secretary respect, national chairman and secretary respect, it will appear INEC recognized that as at that time. And this happened even before the case was instituted in court. This was as far back as July. So it depends on what you want to interpret the status quo antebellum. Was it when Rafonso stepped down? Was it when INEC monitored that convention? There was no case in court that time, don't forget. There was no case in court as at the time they gave recognition to...
as a very senior lawyer, of course, you remember the case of Laduni versus Kukoyi on protecting the rest.
Yes.
Because when status quo antebellum is involved, you are telling the court that, please help me, protect me.
Yes.
And the court is saying, no, you go back to before the hostilities began, because that is the context here that INEC was explaining in those 5 cases. And anybody who remembers the Laduni versus Kukoyi matter is also talking about what's the subject matter, the rest, protecting it. But give me a moment, Mr. Osasiusi, because we're going to break, and when we come back, this interpretation, they say we will not recognize anyone. Now, ADC is a persona non grata. As far as it is now, is in the balance. His leader is rudderless as far as the regulator is concerned.
He's dead for now.
But the problem is that the rest is also in danger because by the time the court comes back, it will be too late. Fait accompli. But we'll be back after this break, everyone. Thanks so much, everyone, for staying with us. So, for those who are lawyers or those who have the Laduni and Kukoyi case of 1972 that I made reference to is going to resonate to anyone who remembers the conversation around status quo antebellum, because the conversation is how to protect the rest, protect the subject matter. Now, the rest here, Mr. Osasiusi, will be not messing up with the leadership of the party, which is in context. Here. Now, the question is, by the time what INEC is running away from is they don't want to be found guilty of taking sides. And that's why the chairman said, let's leave things open. But then, what is the danger in leaving things open? Because primaries are supposed to start in April and end in May, I guess.
That's correct. Now, the Court of Appeal gave that order. The Court of Appeal did not say, don't recognize either faction. It never said to say preserve the rest. What is the rest? The political party and its ability to function as a unit, as a registered political party in the country. That is the rest of this thing. If you don't have a national leadership, that means the party cannot function. You are actually destroying the rest if you do not recognize either person. It means the party cannot give you notice of convention. It means the party cannot give you notice, cannot sponsor any candidates. That is the effect of the decision now of the commission. Because if you don't recognize any national chairman, if you don't recognize any national secretary, how does the party function? Your rules say, your regulations say, you need the national chairman and secretary to endorse notice of convention, notice of candidates, and every other notice that has to be done, every communication between you. And now you have cut off the line of communication between the party, which is still in existence, has not been registered. You cut off the line of communication between you and the party. You do not recognize the party, in other words.
Especially now the party has become a mainstream opposition party now.
Well, it's a mainstream party, but it should not happen to any party at all. But more so because of its importance and because of the people who are now members of the party. People recognize it. The presidential system. So quite honestly, you don't recognize government party and opposition party. But yes, in the colloquial terms, it is now the main opposition party. And you say the main opposition. We're almost back to those African countries where the main party is the only recognized person, and you have tiny little things that go around there in the pretext that you have multi-party democracy.
So what this means is that fundamentally and realistically, technically speaking, anyone who is running on the platform of the ADC is in danger of being on the ballot. That's technically,
or being excluded from the ballot because, first of all, the Constitution says you must belong to a party and sponsored by that party. In the extrapolation, in the interpretation of those things, for you to show that you belong to a party, the national chairman and secretary have to introduce you to the commission, to INEC, to say this. INEC says, no, we're not going to accept any communication from this person or that person, from anybody. Because INEC has not now recognized anybody. So it's a danger of the party not functioning as a political party, not being able, and the main object of the political party is to sponsor candidates at elections.
In the eye of the law, based on the pronouncement of INEC, ADC does not exist. Technically,
the effect of it all, that's what it means, because you will invite them for meetings with political parties. You will accept lists of candidates from them. You will not accept any communication from them. You will not have any dealings
with them.
You will not relate to them, have any dealings with them. That is not the intention of the Court of Appeal decision. Preservation of the rest is to preserve that political party as is.
For someone who has worked in INEC and with your, without miscalculating, over 35 or so years and the bar.
Yes, 42 years.
42 years.
43 years.
If you were in the shoes of the present INEC leadership, what would you do?
Now, there are antecedents. Don't forget, our memory tends to be very short. A similar crisis arose in AD, Alliance for Democracy, at that time, after the ACN was formed.
Yeah.
A few people remained behind in the AD, and were causing a lot of confusion. What did INEC do? INEC invited them and tried to intercede, and partly because of that, INEC set up an EADR, a committee for disputes, so that there can be alternatives to litigation. And I think they were able to settle, by and large, that AD crisis as at that time. We can take a leaf from that. Intervening in terms of trying to resolve issues. I think there's an attempt to the PDP in this present commission trying to resolve the issue of the PDP. But I'm not aware that they tried to do so in this. Apparently, they've been simmering maybe July, August, up to September before it went to court. I don't know what the commission did, whether it's intervened, I don't know. But that is one of the things to be done. But you must recognize one person. As a regulator, you have to ensure that the people you regulate are alive and kicking. But you are a regulator of democratic institutions. You must ensure that multi-party democracy is sustained. And in order to do that, strong, virile political parties are an essential, integral part of democracy.
So you think INEC erred in this? This is an error of judgment, do you think?
I will take a different view than what the commission did, yes. Yes.
This was not the best. They could have done better.
In my own opinion, this was not the best way to go about it, because you have, with the best of intentions probably, but you have now had a situation where you have almost destroyed that party as a political party. It no longer has all the attributes of a political party.
So let's close now. Just in 10 seconds, if you are to give, and if they need to pay for the legal advice, if you are to give a legal opinion and an expert opinion to ADC, if you're any member of ADC, what should they be doing now? Just in 10 seconds.
Well, I think they should try and resolve this issue. There are two ways. Either go for accelerated hearing of that case and ensure it's dealt with speedily, or get some kind of clarification or compel INEC to do what it has to do to preserve the rest of the party.
Mr. Oluwole Osazuzi, many thanks. Always a pleasure having you.
It's a pleasure to always be here, and I must assure you that we do support you, and all the attempts to muscle the press and the threats to you. We sympathize, do well with you, and we back you, and well with you.
Appreciate it. Thank you so much indeed. Appreciate it.